Hi, welcome back. This is the sequel called Tell It to the Judge. And in this particular format, I have some cases. I'm Eileen Nadelson, by the way, judge retired. During my tenure, I sat on the civil and criminal side of the bench in New York City. And before I moved to Lewisboro, I heard a lot of interesting cases down there, and I thought I might want to share them with you. I think you will find them interesting also. Some of them even amusing, and of course they weren't too amusing for the parties at the time. But why am I doing this program? Because I really firmly believe that we learn from each other's mistakes, and these are everyday occurrences that could happen to you or me, and they have points of learning and lessons to be heard on what actually occurred in the courtroom with real people. All right, so I'm going to jump right into the first case, which I will term the mystery of the pink poodle. I heard this fairly early in my tenure, and I thought it was quite interesting as actually eye-arching, and I'll explain why. Enter the plaintiff. By the way, when we say plaintiff and defendant, there could be lawyers there, and usually they are, but we don't say, and the lawyer said for the plaintiff, and the lawyer said for the defendant. We just refer to the plaintiff and the defendant because it's their positions that we are talking about. So enter this plaintiff who purchased a cute little white poodle from a pet owner, a pet shop actually. And it's now a year later, and the poodle turned a bit pinkish. It's got a pinkish hue, which I was told at the court in this particular case, that happens to be rare. It's a rare occasion, but sometimes dogs do take on a peculiar kind of mutation kind of color. So this woman who had bought this cute little white poodle went back to the pet store and said, "You sold me a defective product. I bought a white poodle. It's now a pink poodle, and I want my money back." And he said, "Okay," because now he has a rare, but he's only too willing to take it back. He said, "Okay, I'll give you another white poodle." She said, "Oh, no, I'm not giving you my poodle back. I love my poodle. I just want my money back because I have a defective product. I didn't get what you sold me." And he said, "I don't think that's going to work." It ends up in court. The woman is suing the pet shop owner for a defective product, all right, and wants her money back. The case comes before me. I hear the testimony, and I have to decide, this is a decision for me, is the pet owner responsible for giving a product that was not originally allegedly bought, or does he have to return the money, or does the woman have to return the product in order to get her money back? And my decision, what do you think? My decision was, you can't get your money back unless you return the product. I mean, unless the owner or the manufacturer of the product says, "Okay, toss it, I don't want it back." But if the manufacturer or product owner wants the product back, you're going to have to return the product in order to get your money back. That's how it works out here in the real world. And so my decision was for the pet owner, or the pet shop, I should say, and against the woman. She could not get her money back unless she returned the dog, which she didn't want to do. And now I'm going to jump into my next case, which is about an engagement ring. This is a man and a woman who were going to be married. He gave her an engagement. The engagement ring was given to this woman, and she broke off the engagement, decided she doesn't want to get married. So he said, "Well, I gave you that engagement ring in contemplation of us being man and wife. If you're not going to be my wife, I want that ring back." And she said, "Oh, no, you gave that ring to me because you love me. It's a gift. It belongs to me now." Oh, okay. Now the man is suing the woman. They're in front of me at court. And the testimony of the parties is they were out for an evening. They went to a nice place for dinner. They went walking through the park, and it was a kind of romantic evening out. And somewhere along the line, he said, "I love you. I want to marry you. I want to spend my life with you. I want to have children with you. And I want to give you this ring to show you my love for you." Words like that. I don't remember the exact words, but it was all expression of how he wanted to marry her and how much he loved her. And both agreed that's what the conversation was. All right? So now I have to decide, the decision for the judge is he entitled to have the ring back? Because if he gave her the ring, if you give a ring on condition of something, in other words, you don't follow through on the condition, and his condition was you had to marry me, he gets the ring back. Or did he give it as a gift? And if it's a gift, she gets to keep it. Right? So now I'm going to let you think about this. What would you want the judge to do, or what would you want to happen if you were one of these parties? I'm going to give you a few seconds to think about what do you think is the right course. A few more seconds. Okay, here's what I decided. Nowhere in the testimony did he ever say, I give you this ring because I'm thinking of us getting married. I'm giving you this ring because I know we're going to spend our lives man and wife. I'm giving you this ring because that's what I intend for you to be my wife. Nowhere is anywhere in that conversation. It's all about I love you, I want to spend my life with you, we're going to be together. That is an expression of love, and the gift and the engagement ring is an expression of that love, and therefore it's a gift. So decision, the woman gets to keep the ring and the man does not get the ring back. Right? So if you want to make it clear about giving somebody, if you have a pendant and you want to give it to your niece or your daughter, and you could make a condition on it, you could say, you know what, I'm giving you this very valuable pendant that's been in the family for years, but I'm giving it to you because I want you to graduate college. This is for you if you graduate college. That's a condition. If she doesn't graduate college, you can get that pendant back. But if you just give that pendant, you know, this has been in the family for years, I just want to pass it on, I want it to stay in the family, I love you and I chose you to keep it, that's a gift. So no matter what happens, she gets to keep it, right? Distinctions are important here. All right, now let's go to a case that pretty much happens every day in life. This one is about a painter and a homeowner. And the homeowner hired this painter to paint his house, and the painter sent him a contract about, you know, his name and a form contract that he had in his file. It's a form contract, has his name and what he's going to do. He's going to paint the house and shows the things he's going to do for the homeowner. And at the bottom, he had the amount. I'm going to make it up at $1,000. Let's call it $1,000. It was a lot more than that, but let's call it $1,000. So he sent him this contract, but at the top of the contract, under his name and the painting notation, he wrote in handwriting, in his own handwriting, this is a guesstimate, written in, right? When the job was done, the painter, turned out the painter cost $1,500. I'm making that up again. Cost $1,500 to paint this house. So he sent the bill saying, you owe me $1,500. And the homeowner said, wait, I have a contract. It's a formal contract here. It says $1,000. I don't owe you any more than $1,000. No, but the painter says, I said it's a guesstimate. It's not a formal contract anymore. I said it was a guesstimate. He said, no, you can't do that. This is a formal contract. Okay, it is now at court. The painter is now suing the homeowner for that additional monies of $500, assuming that he got paid for $1,000, all right? He now wants his additional $500. Could have been less. A guesstimate means it could be less, but that's likely not to happen. So he's in court. They both are in court, and the painter wants $500. So now, this is for you to decide. Again, you can choose whether you want to be the homeowner or the painter. What do you want the judge to do on this? Is it a formal contract, formally typed contract with a bottom sum total? Or has it been altered and now is a guesstimate by the handwriting? You think about that. I'll give you a few seconds again. A few more seconds. Okay, here's the decision. When it was written in, this is a guesstimate, nowhere in any of the evidence, nowhere in any of the testimony, did the homeowner, or could he show for that matter, nowhere could the homeowner show that he had disputed that written in guesstimate. He never said, what do you mean by a guesstimate? How much more do you think it might cost? What are we talking about? Does it take more time? There was not one piece of writing material, email, telephone call. There is nothing that could be displayed to the court, which is the judge, on whether or not he had objected to this man writing in, this is a guesstimate. And by law, when you alter a contract, this is a form contract as it was, but when he wrote in, this is a guesstimate, that is an alteration of the contract. It becomes part of the contract, and it is now a guesstimate. And if you don't like that, if you're on the other side, you have to dispute it. You have to either cross it out when you get the contract, or you have to call him up or send a letter or something. I don't like it being a guesstimate. Tell me how much you think it's going to cost extra. These are things that the other side has to dispute, because if there's no objection, you take the contract as it was altered, meaning it is now a guesstimate. So, decision of the court, the painter is entitled to the extra money, and the homeowner has to pay him that extra money. Now, I wanted one more thing before we close down this segment. I'm going to give you a case which is a little bit different from the ones that I've been talking to you about. This one has to do with a jury. Whenever there's a jury, the judge no longer makes any decision on the case. I am not allowed to make a decision on the case. If there's a jury on the case, the jury is the one that makes the decision on the case. So in this particular instance, it was an accident. One party injured the other. I think it was an automobile accident, as I remember. He hit his automobile, or allegedly hit his automobile, and he injured the other party. And now the party who was injured is suing the man to pay for the damages, the medical expenses and things of that sort. And this was a jury case, which means I am not making this decision. I get to put no input in here at all, right? So the jury goes out, and the question for the jury was, is the defendant negligent? In other words, first you have to find that he's guilty of what he did before you could decide that he owes any money to that person. So the main question was, do you find the defendant negligent in causing these injuries? And they go out to deliberate. By the way, I have to tell you one other point. This is a civil matter because it's an injury case and it's money. It's not a criminal case where you can go to jail. That's the distinction. And in a civil case, you don't have to have 12 jurors. You can have 6 jurors. And unlike a criminal case, where all 12 jurors in a criminal case, it has to be unanimous, there can't be one dissent. All 12 people on the jury have to agree that the person is guilty of the crime. In a civil matter, you just need 5 out of 6. You could have a unanimous, but you don't need unanimous. 5 out of 6 can determine guilty or not guilty, or liable or not liable, as we say in the civil term. So the jury went out, and the day passed, and the jury said, you know what, Judge? We're not going to be able to come to a decision. We can't get 5. We can't get 5 people. It's being deadlocked. So as a judge in a jury trial, it is my job now. I'm not making the decision on the case, but my job in a jury trial is I have to press the jury to continue deliberating, think of all the facts, get all the papers back again, look at all the documents if you have to. The job of the jury is to make a decision for the parties. I can't make that decision. So I said, you know what, press yourselves, think about the facts, come to some kind of conclusion. Next day, jury goes back into deliberation again. Sometime in the afternoon, I get a note from the jury foreman. Judge, we're not going to be able to come to, there's no way that we can get 5 people to decide this case. We are definitely in a deadlock. I bring the jury out again, and I say, your job is important. These parties need a decision. Somebody has to know whether or not he's going to get his money or not get his money, or somebody has to know whether or not he's liable for this or he's not liable for this. Somebody is going to have win or lose in this case, and it's your job to decide that. So I need you to go back again, this is the second day now. I need you to go back again, look at all the facts, look at all the evidence again, be very diligent about what you're discussing, talk it over with each other, and try to come to a decision, okay? They go back into the jury room. I get another note, this is hours later, We're on the third day. This is third day now. We decide we're coming back for the third day. Third day they come, they're deliberating. I get another note from the jury foreman. Not a chance. This is not going to happen. No way. We cannot get 5 members to decide on this case. One way or the other. One way or the other. So now I am now in the case decision to an extent. I have to decide at that point as the judge, do I dismiss the jury and call it a mistrial? Because that's all I could do. I can't make a decision on the case. So I have to decide then, am I going to allow this jury to disband and the case could come up again, or do I press them further? And I decided, oh, well, wait, I'm going to give you a chance to do this also. What do you think the judge should do in a case like this, when the jury is not being able to come to some kind of conclusion? What do you think the judge should do? I'll give you a couple of seconds for this. Okay, let me tell you what I did. I decided that it had to be a mistrial. I pressed them for 3 days. No way could they even get 5 people to agree one way or the other. Obviously, there was not going to be an agreement on this case. To keep this jury going on this civil matter would not be fair to the parties. They'd still be wondering what's going to happen. And it was just antagonizing the jury members. So my decision was, we can't press this any further, and I decided that it had to be a mistrial. And that's how I decided that. So I just want you to see that when I'm not involved in making a decision, I may get involved. It's very rare that this happens, but I happened to get one where the jury was hung up, so to speak, and I had to decide whether or not to dismiss them or not to dismiss them. And that sort of brings you to the kind of things that happen out here, the circumstances that could happen to any one of us, you or me. And I would like you to be vigilant and diligent and alert about what's going on in your life. You have to look at contracts. You have to think about what's going on when you're dealing with somebody. And if you would like to run a situation by me and have me discuss it, I won't give any names. I won't talk about any particular circumstance, but I will use the topic. So if you have something that is being a dispute for you and you want to hear what a judge might say in your dispute, all right, you can let me know and I'll use it on the show. And the way to contact me, if you have something you want to tell me about, I will give you a phone number, 917-327-6487. That's 917-327-6487. It comes directly to me, Judge Nadelson. And let me know if you want me to use the topic on the program, and we'll see how it turns out. I'll give you my opinion on that. Meanwhile, I would like to thank you for viewing and listening to the program, and I wish you friendly and happy dealings out there. Thank you.
You're watching Lewisboro Community Television, Channel 20.